Welcome to Road to Recovery.
Hi, everybody. This is Sagi Shaked. We're here on the Road to Recovery podcast. And today we have a special guest, Michael Greenspan of Greenspan & Greenspan in New York. And Michael is going to talk to us a little bit about New York law and obviously related to trucking. So you're going to get new information about New York law, what you need to do, and then a lot of details on truck accidents in New York. So, Michael, welcome to the show.
Thanks for having me. Look forward to speaking with you.
Yeah, absolutely. It's going to be fun because we're going to go over a lot of topics and get to pick your brain on New York law. So the people who are listening to the podcast and don't know anything about New York law, not to make mistakes, because we've all been there where we get involved in a state that we shouldn't be involved in and don't associate counsel that knows what they're doing in that state and make mistakes. So you're here to make sure nobody makes those mistakes. So let's start off with this. I see that you, I obviously I know you. You're a friend, and you lecture a lot to other trial lawyers. So this is kind of we're going to steal some information from your lectures here, if that's okay. So you've lectured a lot. How long have you been practicing law, and how long in New York, actually?
So I practiced, this is my 33rd year of practice. I've been practicing in New York the whole time. And for 27 of those years, I was privileged to be in partners with my father, Leon Greenspan, who was the founder of the firm.
And so what you do mainly do personal injury, or you do any other areas?
Yeah, we primarily focus on personal injury cases, all sorts of motor vehicle crashes, truck matters, and also construction accidents in New York.
Speaking about motor vehicle accidents and truck accidents, in Florida, it's a little different. Like when we have cases, we talk about PIP coverage, and then you talk about threshold. So in Florida, for example, there is no mandatory bodily injury coverage. You can drive around with no bodily injury coverage. Is that something that New York has, where people can drive around and have no coverage?
No. We are a no-fault state. So that means there has to be a minimum of at least 25,000 in mandatory bodily injury coverage on every vehicle that's garaged in New York. But it also means that you're subject to our no-fault law. And what the no-fault law gives, it also takes away.
Yeah. So what does that mean when you're subject to the no-fault law? I'll tell you what Florida is. Florida, we also have a no-fault law, and that means we have to prove, in order to get pain and suffering money, all we have to prove is a doctor has to say that the injury is within a reasonable degree, permanent within a reasonable degree of medical probability. And there's some other factors, but that's the main factor. What do you have to prove? I heard it's a lot harder in New York. I'm licensed in New York, but I don't practice there often. So since you're a local and you do it for many, many years or decades, give us a little bit of what it means, this threshold defense that you hear about a lot.
Sure. So back in the early 70s, our good friends up in Albany came up with this no-fault law. And in order for you to successfully sue for injuries as a result of a car crash, you have to have one of 9 types of injuries to constitute a serious injury. That's our threshold. Now, what's odd about it, of those 9, one of them is a fracture. It doesn't have to be a displaced fracture. It could be a fractured pinky. And that's enough. As long as it's a fracture, once you can show you've cleared one aspect of the threshold, every other injury that your client has, no matter how insignificant, can now be compensable. But that's the easy case. The real tough cases are the ones which have to go under one of the other categories of the threshold. And for our purposes, the first 6 of them don't really matter. But when you're dealing, let's say, with a back or a neck injury, or let's say a shoulder injury, or even a TBI, you have to show you're on one of the other categories, which require you to fit your injury into some really dense language. So let me give you an example. One of the categories, you have to show that you have had a permanent consequential limitation of use of a body, organ, or member. Okay? Or the
What
other
does that
one, you have
mean?
to have a significant limitation of use of a body, function, or system. Right? So you've got this dense language, and you notice what's not in there. It doesn't say disc. It doesn't say tear. It doesn't say TBI. It doesn't even say, fusion surgery. So cases are won and lost in New York when you don't have a fracture on those areas of the serious injury threshold. So you have to know how to prove your case and what the elements are in order to meet that threshold. Or no matter how badly you're hurt, your case will be dismissed well before trial.
Wow, so that's a lot different than Florida because, again, in Florida, if a doctor says it's permanent within a reasonable degree of medical probability, as so long as the jury believes it, you get to that next step. You're saying in New York, it's different. So if someone has, for example, let's say a herniated disc or a traumatic brain injury, which is something it's not a fracture, it's an injury to the brain, and sometimes you can't see it. They call it the invisible injury. How do you go about getting someone compensation? I know it's a loaded question, but just give us generally how you would go about doing that.
Yeah, so it requires having the treaters first submit narrative reports because these cases tend to be fought on motions for summary judgment before trial. So you have to have narrative reports from these treaters, and they have to be able to give the indicia that show that your client's injuries were, number one, caused by the crash, and number two, that they meet these requirements. So there's either a qualitative or quantitative assessment to fit within this very dense language. And the reason I started with, this came up in the early 70s. We didn't have MRIs back in the 70s. We didn't have DTI. We didn't have a lot of these things. So the legislature worked with what they had, in which what was standard of care back then, X-rays, that they had.
So you would be putting up in New York, you'd put up the MRIs, and your doctor would say that the herniated disc is pushing on the nerve, and that's what's causing the radiating pain, and that's permanent, something like that.
Yeah, but not only that, then you have to show what is the range of motion in orthopedic injuries as measured with a goniometer. So these are things that these are judge made. So you ask your expert, hey doctor, when you were in medical school, did they ask you when you were treating a patient to measure the range of motion of his neck or his back? Doctor would look at you. What do you mean? Or ask you to review photographs to see if, this kind of damage would cause this type of injury. But you have to know what the courts are looking for. You have to know what the case law is. And this is one of the areas that we lecture on New York auto practice, is how to be able to have those reports and have the case law unified there so that you can beat that defense motion to dismiss your case on the threshold. And if you do it right, and we go affirmatively, we want to have a judge determine before trial that my client did have a threshold injury. So we don't have to have a jury worrying about it, because it's a real problem at trial.
But can the judge determine there's a threshold if the defense comes forward and says it's not a threshold? Because that's what they do in Florida. We'll have a doctor say it's permanent. They're going to find a doctor that says it's not permanent, no matter what the injury is.
Well, I'm sure. And then that case will at least, then you have to go to a jury. But, when you have the right experience and the right information, sometimes you can get in the defense medical report enough information to say, hey, judge, based on their own expert, this meets threshold on this category. And if it's done appropriately, look, you can't do this in every case, but
Right.
you always have to be thinking outside the box. And listen, I have very little use for insurance companies, as do you. But what they do respect is tenacity and really pushing them at keeping them on their heels. And that's what, it's our obligation as trial lawyers to do, is keep the defense on their heels, destroy their defenses. I know that's, it's something that you certainly practice in. And so one of the ways if we know the battle is to be fought on thresholds, we're going to go attack that with everything we have.
I love it. I love it. All right. So let's move away now from the PIP threshold. And I want to talk to you because we spoke earlier before the show at several conferences that we had been at. And one of them, which shocked me, in Florida, the wrongful death statute is completely different than New York. So Florida, if someone loses a loved one, they can recover for their mental pain and suffering, their loss of companionship, and everything surrounding that. But I understand New York law is completely different when it comes to what a survivor can recover, if anything. And that's why I'm going to put it in your hands to tell us, you know what Florida is now. What's New York like for wrongful death?
It is awful. Now, New York is always looked at as a politically liberal state, a blue state, but our state's wrongful death law predates the Civil War. Okay, this is where it's from. So at that point, women certainly didn't have the right to vote, and in some cases, even considered property. So our wrongful death law does not permit grief damages for the surviving spouse or the surviving family members.
Wait,
And it
you're
does
telling me that the family can't get for their own pain and suffering?
not a dime, not
Wow.
a dime. Instead, the law is only concerned with two things: one, conscious pain and suffering, and two, the pecuniary loss to the distributees, to the family members who would take under if there's no will.
So the
So,
pecuniary loss, is that the money, like income that they would have lost? Is
yeah,
that what you're talking about? And
that's
then
right.
what's this conscious, explain that to us. What do you mean the conscious pain and suffering of I mean, I think I understand it, but explain it to us.
Yeah, this is one of the hardest parts of the practice is sitting with the parents, let's say of a kid or teenager who's been killed, and explain to them that we have to show that in the moments before the crash, that their child or their loved one was had a fear of impending death, that they knew they were about to die, and that after impact, but before they died, they were conscious, so that they were aware of in some level of their pain, and you can get compensated for that. So imagine having to, as human beings, we want to know that if their loved one was killed, they died instantly. We don't want to think that they suffered. But in our wrongful death law in New York, we have to show the exact opposite. We have to show some evidence of conscious pain and suffering. It could be, 30 seconds or so. And by evidence that they were moaning or just, gripped somebody's hand or something. There has to be, and sometimes you even have to have a forensic pathologist testify to it. So it's just awful and it's gripping. And,
It,
the
it sounds
examples came.
awful.
Oh,
It
it
just,
is.
I mean, how is it that you lose a loved one as a result of someone else's negligence, and then if the person dies instantaneously, the family gets basically nothing for someone? I mean, that's basically, you get to walk around and it's just horrible. That's horrible. Has the trial lawyers organization done anything to try to change that in New York? Because that just sounds like really, old and archaic.
It is tremendously unfair. And 4 years in a row, there has been a bill that has passed both houses of the legislature in New York called the Grieving Families Act, which was meant to rectify this wrong. 4 years in a row, including as recently as last week, Governor Hochul has vetoed it, a Democratic governor. So
And insurance
we've
lobby is
tried.
strong. Insurance lobby is super strong, I guess. Yes, it's a democratic state, but I guess the lobby group has their puppet, and they can do whatever they want there, because it makes no sense that the people wouldn't want this to pass. Um,
Well, it's the
Horrible law.
same cry, Sagi. The insurance industry, the healthcare industry, this is going to raise premiums. This is going to make it way too expensive. Insurers are going to leave the state. So we've tried, and we're going to continue as part of the New York State Trial Lawyers Association, which I'm a member, to change this. Because imagine sitting in a room with parents and having to explain to them that their teen's death is worthless because their son or their daughter was killed instantly, and the teen wasn't supporting them, wasn't paying them rent, wasn't providing for their financial needs. So, or at the same thing with grandma. And we saw this in like in 9/11 cases. So grandma who's killed, who is beloved by her family, but is long since retired, doesn't earn anything and isn't supporting anybody. Her case is worthless. But somebody who's an executive at a hedge fund or a bank who leaves a wife and kids, who's killed instantly, that case is worth far more under our statute.
Yeah, completely unfair. Doesn't make any sense at all to
No.
me. Well, let's, we've covered initially the threshold, and we've covered wrongful death. I want to cover one more area, and then I want to get into some truck specific cases in New York, obviously, so people can, better understand the law. But one more thing. So some states have what they call bad faith conduct on the part of the insurance company when trying to settle cases. In Florida, we underwent a recent reform with our legislature here. So we'll sum it up in like 5 minutes. In Florida, there is good bad faith law. I mean, we do have to give the insurance company an opportunity to pay, and there's a whole 90-day period. What's your equivalent in New York, if there is anything that holds the insurance companies accountable when they play games with people's lives and don't pay the money in a timely manner?
It's very difficult in New York. We don't have anywhere near the protections that Floridians have. And to get an insurance company on the hook for bad faith damages requires you'd go through an extreme amount of hoops, and it almost never occurs.
Yeah, that doesn't keep the insurance companies honest when they can play games. Basically, string you along all the way for years and years and years, and then they don't have to pay anything as a penalty.
Right.
That's a problem.
And
Um,
that's why they'll take cases to trial, because they really don't have any risk to them.
okay. And so one more. I know we said bifurcation. Sorry, bad faith would be the last one. Let's do one more in terms of when we talk about an action against a government, and then we'll roll right into trucks on our next episode. So this episode, we're just going to go some various differences. In Florida, we can sue the local government or state government, but there are caps on damages unless you get a claims bill passed, and our cap is $200,000 or $300 per accident, $200 per person. Um, First of all, do you have a cap in New York? And then the second question, are there, there's some loopholes here in Florida that you have to follow, but tell us the loopholes in New York if there are any, and is there a cap?
Okay, so let's take it in reverse. There are no caps on damages in New York. So that is certainly a benefit. But the upshot of that is, however, is verdicts can be reduced in New York, first by the trial judge in a post-trial motion, and then by our state's appellate court, the appellate division, who is empowered to make their own facts and can say that the verdict against whether it's a governmental entity or anybody else was excessive, and they can just reduce it. And if the plaintiff attorney doesn't agree to it, they get a new trial.
Is that in
So,
all cases or just government cases
no,
specific?
that's in all cases.
Okay.
That's in all cases. So the defendants have that, arrow in their quiver. And then with the government cases, in New York, you could depend on who your government is depending on what court system you're going to use. So real quick, if if your person is injured on the New York State Thruway by a New York State Thruway truck, well, you don't go in our regular court system. You have to now uh, commence proceedings, what's called the Court of Claims, and you only have 90 days to file and serve an initial documents on the state and the appropriate governmental authority. So you've got to go and meticulously follow the statute and the rules on what has to be done, who has to be served, and if you miss that 90-day time limit, that's a real problem. Now, there's a way to extend that 90-day time limit once you've done an initial act, but again, any case against the state, you have to. And now, if you're in the Court of Claims, here's the other issue: you don't get a jury. It is an appointed
Ooh.
judge who is going to decide facts and damages.
Yeah, that's completely different than Florida. Like Florida, we have to put them on notice within, once you put them on notice, they have 6 months to investigate. You can't file suit during those 6 months. And then you have 3 years from the date of the accident to bring the lawsuit. Now, if you don't put them on notice, and then you can't prove that you put them on notice by certified mail, and you also put the Florida Department of Financial Services on notice, then you're going to get kicked out. So just there are requirements in Florida. It doesn't seem as stringent as New York, but good to know for anyone who's bringing a claim against a local municipality or any type of government entity.
Yeah, and the rules are different than for a local municipality as opposed to the state. The state gets its own court, the Court of Claims. If you're suing the town, the city, the county of, now you have 90-day rules, and you've got to follow the 90-day rule properly, and then you have a year and 90 days to commence suit. against a municipality, but there are certain requirements you got to go through. We don't get overly technical, but basically your notice to the municipality has got to be extremely detailed, served and filed on the right people and on time. Because if you don't, you're just like in Florida, you can get your case dismissed, no matter how meritorious, no matter how bad the damages are.
And the easy answer is if you got a case, don't play around. Get to someone like Mike who knows what they're doing, because if you're out of state and you're trying to dance in New York, you can get into some big problems. Mike, I want to thank you for this first episode. We're going to do another episode with you and specifically address the truck-related questions for New York. So thank you for being on today. Appreciate your time and your wisdom and your knowledge and sharing all the differences between at least Florida and New York, because there are major differences.
No, it's my pleasure. Glad to be of help.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.